Hello and welcome to Sherayzen Law Office video blog. My name is Eugene Sherayzen. I'm an international tax attorney and owner of Sherayzen Law Office Ltd. And today I'd like to talk to you about a situation where an account was disclosed on Form 8938, but it was not disclosed on FBAR, or as it's known by its official name, FinCEN Form 114. Does your disclosure on Form 8938 replace the FBAR non-disclosure? That's a question that I often hear from taxpayers who come and talk to me. And the answer is no. Unfortunately, just because you disclosed an account on Form 8938, that does not in any way eliminate your obligation to report the same account on Form 114 or FBAR. Will it help your non-willfulness case? Yes, it will. But you still have to file your FBAR. You still have to disclose on FBARs all of the foreign accounts that you are required to disclose. Otherwise, you are on the hook for the penalties. Even if they're not willful tax penalties, there may be non-willful penalties. It will depend on the particular facts and circumstances of your case. If you would like to know more about your FBAR compliance, you can contact me at 952-500-8159, or you can email me at eugene@sherayzenlaw.com. Thank you for watching. Until the next time.